Hi, everyone, and thank you so much for joining us today for our webinar on employment-based green cards. My name is Dustin Saldarriaga, and I'm a senior associate with Scott Legal PC. Joining me today is our partner, Kelly LeGrad Weiner, who has extensive experience guiding clients along the path to employment-based green cards. A few things before we get started with our presentation. The first is, although our firm does focus on business immigration, we are a full service immigration firm. So whether you have questions about family-based U.S. immigration, humanitarian U.S. immigration, or anything in between, we do hope that you won't hesitate to reach out to us with any questions. We'd be happy to help. Also, we will be following up this presentation with an email with a number of items in it. One of the things you will see is a link to sign up for our future webinars. We try to do at least 2 of these webinars a month, and I think at this point we're doing about 2 a week, and those cover a variety of topics. So do sign up for those if you think they'd be helpful. The email will also have a link to our YouTube channel where we post a recording of this webinar, as well as a variety of shorter videos. And again, those span the full spectrum of US immigration law, and we do hope those are helpful to you. If you have any questions during the presentation, you can send them in using either the Q&A function on Zoom or the chat function. I have both open on my screen, and I am monitoring both. And if you do have questions about your specific circumstances, we do hope that you'll schedule a consultation. The email we will follow up with will have information on that. So without further ado, I will go ahead and pass it off to Kelly to give us an overview of the employment-based green cards and speak about the EB1, EB2, and EB3 options.
Thank you, Dustin. Perfect. So we're going to, talk primarily today about EB2 and EB3, particularly the PERM process, but wanted to also just mention some of these other categories, describe them very briefly. We do have some other webinars that go over some of these in more detail. So for example, there's the EB1A. This is for individuals of extraordinary ability who have achieved sustained national or international acclaim and reached the very top of their field. You can self-petition for these applications, which is very helpful. There's the EB1B, outstanding researchers and professors. So if you're in the academic space, this may be something to look into. EB1C, multinational manager or executive. So this is often, people who maybe were transferred here on an L1A as an executive or manager, and they were an executive or manager abroad, perhaps, may pursue the EB1C. There's the EB2, and this says, as a threshold requirement for the EB2, you either need to have an advanced degree, which means a U.S. master's degree or equivalent or higher. Equivalent would be U.S. bachelor's plus 5 years of progressive post-baccalaureate work experience. The EB2, you can go through the PERM process, which we'll talk about more in detail today. You also can get an EB2 under something called the National Interest Waiver. So this is where you ask the government to waive the PERM process, to waive this requirement of testing the U.S. labor market. And you do so based on having an endeavor that you're engaging in that has substantial merit and national importance, proof that you yourself are well positioned to advance that endeavor. And then based on that, you'll argue that on balance, it's beneficial to the U.S. to waive the PERM process and the labor certification. So we do have, other webinars that focus just on that, if that's something you're interested in. Then the EB2 you can do through company sponsorship. EB3 as well, you can do through company sponsorship. This is for professionals, which means somebody working in a job that requires a U.S. bachelor's degree or higher, skilled and unskilled workers. So EB4, so this is a category, this is an employment-based category, but covers many different categories for green cards, including, for example, religious workers. We won't really be getting into that today. And then EB5, and this is through investment, creation of U.S. jobs. This is the a category where you would invest either $800,000 or $1,050,000, and go through the process to then create, 10 full-time U.S. jobs. So we also have separate webinars that are just focused on EB5 if that's something that you're interested in. So let's jump in and talk a little bit more about the labor certification process, also called the PERM process. And this is relevant for categories EB2 and EB3. So as I mentioned, this process is driven by company sponsorship. This means that you need a U.S. employer that is willing to essentially drive this process for you. It's not a process that somebody can do on their own. There's not, you cannot self-petition if you're doing, the perm process. And there's really three main steps. So the first and the longest step is the actual perm, the labor certification. And we'll talk about each of, the kind of interim steps in detail. Then, if you get that approved, the company can file a form called an I-140 petition. So this is their petition that says they plan to sponsor you for a green card in the United States. And then the third step is the actual green card application. So if you're in the United States, which is kind of most common, if you're working for a company and they're sponsoring you, then you would file something called Form I-485. And then if for some reason you're outside the United States, or you don't want to adjust status in the US, you can also get the green card through something called consular processing, which we'll talk a little bit more later. So looking at the perm, the way that the perm process works, as I mentioned, it's employer driven. So the employer is really the one who needs to work with the attorney on getting all of these different steps into place. So first is drafting a perm compliant job description. So in kind of a normal recruitment process, a company is going to ask for, the best, the brightest, the ideal requirements they would have. They might say bachelor's required, master's preferred. But for the perm, you're only permitted to include requirements that are the minimum requirements to do the job in a reasonable manner. So when we are talking to our employers, we'll kind of say, if you had to hire someone tomorrow to fulfill this job, what is the absolute minimum education and experience they could have to perform this job? So oftentimes that, the job description piece involves kind of paring down maybe some of the requirements, refining them, making sure that it really is reflecting only the minimum requirements to do the job in a reasonable manner. Because as part of this process, the U.S. government wants to make sure that the company is fairly testing the U.S. labor market to see if there's any willing, qualified, and available U.S. workers who could do this job. And if there are, then, they want the company to hire those workers. Or at that point, essentially, the perm cannot proceed if you find someone. So the next step after you draft the job description is you get a prevailing wage. So this is where you're going to submit the job description, the job requirements, the location to the Department of Labor, and they will come back and tell you, okay, we think this is a level 2 job, and here's the minimum wage that has to be paid. So once you get the prevailing wage determination, the employer will need to look at that and decide, okay, are we able to pay this wage? And the wage needs to be paid at the time the person gets their green card. So if you're currently working for the company and you get a prevailing wage determination, that doesn't change your current job. But in the future, once the green card is granted, the company needs to be able to pay that wage in order to proceed. Once you get the prevailing wage, then you can start the recruitment process. So this is the actual test of the labor market. This is where the company has to place advertisements, and the types of advertisements and the length of the advertisements are all regulated. So you have to do it in a certain way that the government requires. And so during that recruitment process, which at a minimum is 60 days, the employer actually has to review resumes, determine if the applicants seem qualified, interview them if they do, and if they do find any willing, qualified, and available U.S. workers for the job that they can't fairly eliminate, then the process does have to stop. If during the process they don't find any willing, qualified, and available U.S. workers, then the company can proceed with, they'll prepare something called an audit file. So this is where the company provides proof that they've conducted this recruitment. They'll gather all the resumes, all the evaluation sheets for each applicant, and create this audit file that they'll keep. And then they can go ahead and file the labor certification. And so then this will go to the Department of Labor. And right now, those processing times are taking about a year to get an answer on those. We also have something here about audit triggers. So basically, when you submit your labor certification, there's kind of three outcomes. One is that it can be certified, meaning approved. Another is that it could be denied. And then the third is that it could be audited. And so the PERM system, what an audit means is that they want to see all the proof of the recruitment that was conducted. Because for the PERM system, what you're doing is you're submitting a form where you attest Yes, I've placed advertisements. Yes, I didn't find any workers. Yes, there have been no layoffs. And essentially the government is taking the employer's word on it, so it's attestation based. Um, but sometimes the government will say, okay, please prove to us that all these attestations are correct. And so that's where the audit file is extremely important. And cases, even after they're approved, can be audited years later. So it is important for the employer to keep an audit file to make sure that they have all that proof. Certain things about an application may make it more likely that your case is audited. So, for example, if the job requires a foreign language and it's not a job like a Spanish teacher, where it's obvious that a foreign language is needed, that can be an audit trigger. Also, any requirements outside of what they consider normal for the occupation. So the Department of Labor has their own standard for what is considered normal for in terms of education and experience requirements for various jobs. And if you're outside of that, you have to provide arguments as to why these are requirements that are necessary to do the job in a reasonable manner. And that can cause the Department of Labor sometimes to audit your case. There's other reasons as well, and some cases are audited randomly. So there's no way to, completely avoid an audit, but you certainly can minimize the risk. For example, if there's any family relationship between the applicant and the owner of the company, that's a major risk as well. So definitely something to talk about, with the attorney when you're at the start of the process to identify any audit triggers and try to mitigate, that risk if you can. So I briefly mentioned timing. Unfortunately, the perm process is taking quite a long time right now. Prevailing wages are taking between 6 to 12 months to come back. The recruitment process itself has to be at least 60 days. And then, the timing for processing the labor certifications right now is about 12 to 13 months. So you could be looking at, for example, almost 1.5 to 2 years of just processing times on the Department of Labor side. Once you get to the end of that, if your labor certification is approved, then the company can go ahead and file the I-140. And a nice thing about the I-140 is that you can pay an additional fee for premium processing. So you can get an answer, quickly within, 15 business days if you go ahead and pay that premium processing fee. If you don't, then it's taking several months to get a response on the I-140. So once you get the I-140 approved, now we're in the third step. So the third step is the green card process. So here we've talking about the I-485. That is a form that is filed with the government if you are pursuing the green card through something called an adjustment of status. So that's where if you live in the United States, you're here, you would file the I-485. You're only able to file the I-485 if your category is what we call current. So right now, for example, in the EB2 and EB3 categories, there are backlogs. So that means that only when you look at something called the visa bulletin, which is something that the government releases each month, there will either be a C if it's current, which means anyone can file right now. There's a green card category available. Or there could be a date in there. And if there's a date in there, then that means you can only file your green card application if your priority date is earlier than the date on that chart. So right now there are some delays. So it is important to talk with your attorney to understand, how will this impact you? Does this mean maybe you need to extend your underlying status for longer? Because if you get to the I-140 stage and then you're basically stuck, you can't file for your green card application. If you want to stay in the US and keep working, you need to continue to, have that underlying non-immigrant visa status that permits you to work. And then as well, when you are at the stage of filing the I-485, or if you go for consular processing, your family members, can also file with you. So that's where your spouse and any unmarried children under 21 can be part of your green card application. Let's talk a little bit more about the green card process, in particular, the differences between adjustment of status and consular processing. So with the adjustment of status, this is, I'd say, the most common route for people in the perm process, because generally, if you are in the perm process, you're in the United States already and you are working for a US company. Not always the case, but very, very commonly. So if you're doing an adjustment of status, generally, this is a situation where you're in the US, your family's in the US, your kids are attending school here, maybe your spouse is working here too. And since your lives are really based here, it's going to be easier for you to do the process in the United States. To go through that process, you would file Form I-485. And once that's filed, you have the ability to remain in the US for as long as that application is pending. Also, you can file for work and travel authorization. You, your spouse, and your children can all file for work and travel authorization as part of this application. And then at the end of the process, usually you'll have an interview with the USCIS officer where they'll confirm, details about your background and your employment, make sure that everything still aligns with what's in the perm application, and then you would be granted your green card. For some people, this isn't the right process. They go through consular processing instead. Consular processing is where you get your green card through a U.S. consulate that is outside the United States. And for some people, they prefer this process because maybe they're not working in the US currently, maybe the job is, the green card job is for a future, the future, or perhaps their underlying status ran out for some reason. Another reason is that potentially, once you file the I-485, unless you're on H-1B or L status, you can't travel until you get the travel authorization approved. And the travel authorizations can take many months, even up to and over a year. So if someone's in a situation where they're not on an H-1B, they're not on an L, and they need to travel frequently, they can't wait for that travel authorization to be approved, then they will need to go through the consular processing process because they won't be able to, if they leave the United States before getting travel authorization, their green card application will be considered abandoned. So for the consular processing, the way that it works is once your I-140 is approved, it's sent to the National Visa Center. Then the applicant will submit Form DS-260 and supporting documents to the National Visa Center. They'll review the file. Once they determine, okay, we have everything that we need, they'll then send the file to the U.S. consulate where you were previously residing, before moving to the U.S., or if you're currently outside the U.S., to the country where you're currently residing. You'll attend a medical exam, you'll attend an interview at the consulate, and then if your case is approved, they will put an immigrant visa in your passport. And then, once you come to the United States on your immigrant visa, they will then mail you your green card after you enter the US. So both are viable options and just depends on your circumstances, which one is going to be right for you. Perfect. So let's talk about who can pay for green card fees. This is a very common question. I think there's some people that, perhaps will come to us and say, well, this company is willing to sponsor me as long as I pay for it. So that is not permitted. Fees related to the perm process, legal and other fees do have to be paid by the sponsoring employer. Once you get to steps 2 and 3 for the I-140 petition and the green card petition, it's a little bit more flexible. Then the employer or the employee can pay, for those fees. All right, so dual intent. So for dual intent, I think this is always an important thing to talk about when we're talking about the green card process, because there are some non-immigrant visas where it's easier to switch from a non-immigrant visa to a permanent green card. And there's some where you need to kind of provide more thought or strategy because they do have a standard that says you cannot have the intent to reside in the US permanently. So, for example, if you're on an F1 student visa, there's a requirement that you have the intent to depart and return to your home country. Even if you're on an E2 visa, which has a lower standard for non-immigrant intent, you still need to show an intent to depart the United States. So, for visas that have dual intent, the H-1B and the L are the most specific. The O is listed here because it's almost like a quasi dual intent visa. There's some regulatory language that suggests it's okay to pursue a green card application while also being on an O-1 visa, but it's not as explicitly allowed as on the H-1B and the L. So it can be, if you are in a situation where you're interested in a green card and you do have an option to switch to an H-1B or an L or an O, it may be advisable to do that, particularly if you're on a visa that has a very strict standard about immigrant intent, for example, a TN visa. While it is possible to, go through the green card process while on a TN visa, it's more difficult because the TN does have a very high standard for proving that you don't intend to remain in the US permanently. So if you do have an option to switch, that can be sometimes something that's just helpful as you go through the green card process. Okay, so let's talk a little bit more about that. Some considerations when moving from a temporary visa to a green card. Timing is always really important, and the timing relating to your underlying temporary visa status. So, how much time do you have left? As I just mentioned, some visas, it's going to be harder to extend them. They're going to be subject to more scrutiny if you get to a certain stage of the green card process. So once the I-140 petition is filed, now an immigrant petition has been filed on your behalf. If you're going to a consulate, for a visa stamp, and you're filling out a DS-160, there's a question that asks if anyone's filed an immigrant petition for you. So for example, if you're on an F visa and you need to renew it, and you have to indicate that you have an I-140 petition filed, that could be a barrier to getting your visa renewed. That's just to say that when you are on a visa like that, like if you're on an F1 or you're on a TN, you would want to either extend or renew that visa if you're going to need to do that before the I-140 petition is filed to ensure you're not, having that issue. You also want to think about, for example, if you're on an H-1B, that will max out at 6 years. So unless you're at a certain stage of the green card process. So you do want to be thinking about that and working with your employer and the attorney to make sure that if you're on the H-1B, that you're doing what needs to be done to make sure the H-1B can be extended, based on where you are in the green card process. Also, you want to think about, do you want to adjust status? Do you want to get the green card through consular processing? I talked in detail previously about why you may want to do one or the other. So it is an important consideration, though. What are your travel plans? Does your family need to travel? Where are you currently living? All of those, who is working in the household? Like, are you and your spouse both working? All those are considerations to take into account when you're determining whether it's better to adjust status or get the green card through consular processing. You also want to think about your family and your children in particular. Do you have children and you want them to also get the green card? If so, you would need to, plan for that strategically, because at a certain age, once your children either, are 21, or if they got married before 21. So they need to be unmarried and under 21 in order to join your green card application. So definitely something to keep in mind if that's, part of your plans. All right, so the green card interview considerations. So it used to be the case that most green card interviews for employment-based cases were waived. That has changed somewhat over the years. They still will waive certain green card interviews, so that is still a possibility. But they have also started doing more interviews for employment-based cases. So if you are called for an interview with USCIS, or if you are going to a consulate abroad, you'll always have an interview. What you want to do is just review your petition before the interview. So make sure you're familiar with everything that's in the petition. Your prior employment, your dates of employment, your dates of travel, your prior addresses. If there's any, criminal issues, like that's something where you want to have all the certified dispositions, possibly a legal memo explaining why you're not inadmissible. You want to organize and print and bring these documents to the interview with you so you have them to refer back to. Or if the government asks for a copy of something, even though they should have the copies, sometimes they will ask. So it's good to have that with you. You also, along with the copies, should bring the originals. So birth and marriage certificates, those originals should be brought with you. They won't be taken from you, but if they do ask to see it, you want to have those with you. Also for this green card process, you have to complete a medical exam. So if you're in the US doing an adjustment of status, that's going to be Form I-693, that your medical exam will be, documented on, and you'll need to bring that sealed medical exam with you, to the interview if you haven't already submitted it. Because the process can sometimes take a few years, it's always good just to make sure that the form hasn't expired. They do have, 2-year validities at this point, so less likely that would happen, but something just to keep in mind. Also, you want to go with proof of your employment, right? So they could ask questions about, especially if you're currently working there, they might ask to see pay stubs. If those don't align with the prevailing wage, they may have questions about that. So if if you're going to get promoted or the wage is going to change after you get your green card, just make sure that you're addressing those things up front so the officer feels comfortable that the employment that's represented in the application is the employment you're going to hold once you get your green card. If you're adjusting status, you also have to provide proof that you have always maintained your status in the US. So if you've ever been in a situation where you fell out of status, you overstayed your I-94, you violated your visa status, those can be reasons why your application could be denied. Luckily, for most employment-based cases, they can take advantage of something called 245K. So this is a provision in the law that allows an applicant to still adjust status, even if there's a prior violation, as long as there has not been more than 100, as long as there haven't been more than 180 days of violations since the person's most recent entry. So this is a big benefit. Like, let's say someone's been in the US for 20 years and maybe they fell out of status a couple of times, inadvertently, just a mistake. Now 245K will allow them to just look back since their most recent entry. And as long as there haven't been too many violations since the most recent entry, they can still adjust status. So very important to be upfront with the attorneys about that when they're preparing the forms, so you can make sure you're preparing your application accordingly. And then another thing to do before the interview is just meet with your attorney, do a practice interview. Even if you feel very familiar with the file, sometimes these interviews can be nerve-wracking, something where you're a bit nervous. The officers do look for that. So definitely important to kind of practice and make sure that you feel comfortable answering the questions so that they feel that you're, a credible applicant. All right, what is porting? So another very common question, can you change employers during the process? Especially because this process takes so many years at this point. It's often the case that people, new job opportunities come up or they want to maybe change their employer. So at many stages of the perm process, leaving, like let's say you have a company that started the perm process for you, they're in the recruitment period and you get a new job. That, unfortunately, the fact that you've had a company doing a perm for you means basically nothing. It doesn't really help you. When it does help you is once you have a green card I-485 application that has been pending for at least 180 days, and the I-140 connected to that either is approvable or has been approved, that's when you're able to port. The I-140 does need to ultimately be approved, but then you can port. And then at that point, your new employer does not have to complete a new perm for you. So it's only at that kind of late stage of the process that you can port, and you can only port in certain circumstances. So you must be porting to new employment that is in the same or a similar occupational classification as the job that was offered in the perm in the I-140. So, for example, if you have a perm approved as, for you as an accountant, and now you're going to become an accounting manager, very likely that porting, that would work. You could, easily argue same or similar occupational classification. If your perm is for an accountant and now, you want to take a job as a wedding photographer, that's not going to work. So there does need to be the kind of that nexus between the job that was represented in the application and the job you're porting to. But there is that flexibility at that late stage of the process. And then finally, can you change employers after you get your green card? So another very, very common question. When you obtain your green card, you are making this good faith attestation that you intend to continue working for the company that sponsored you. The company also is making that attestation. That does not mean that you have to work for the company forever, for the rest of your life. But it does mean that if you quit your job the next day, and then ultimately you apply for some other immigration benefit in the future where this comes under scrutiny by the government, they could ask questions about this. So the most common place this might come up is the naturalization process where you're trying to apply to become a US citizen. They may look back at your employment history. They may look back at the basis under which you got your green card. And if they feel there was fraud, if they feel there was misrepresentation, that could potentially be problematic. However, let's say that you get your green card, you're working for the employer for 4 or 5 months, and then you get an amazing new job opportunity in another state. You can take it. There's nothing that prevents you. Your green card is not tied to your employer once you receive it. So again, you want to just make sure that, if you do change employers, that you're doing so in a time frame where it's reasonable, it's reasonable for you to argue, that you really did have good faith in working for this employer that did sponsor you.
Great. Thank you very much, Kelly. That was extremely informative. We actually have not received any questions. So for those of you in our audience, if you do have a question, do send it in the next few seconds. But in the meantime, Kelly, want to thank you. And I want to remind those of you in our audience that we will be following up by email. Do check out the links we share. We hope you will sign up for future webinars. And if we can be helpful in terms of your specific circumstances, do reach out and schedule a consultation through our website at a time that works for you. So Kelly, thank you again. And everyone in our audience, thank you. We hope to see you again soon.
Thank you.